Thank you. I'm David Kopel. I am an adjunct professor of constitutional law at Denver University Stern College of Law. I am the research director of the Independence Institute. And as always, when scholars from either of these institutions testify, they testify on their own behalf. I will try to be brief. My reading of Roth-Gary is the case was about when does your Sixth Amendment right to counsel attach? And the holding of Roth-Gary is it happens when you were brought before the magistrate, when you were arraigned. That's the moment when it attaches. And in Roth-Gary was the county had this policy that, well, it actually doesn't attach until the district attorney gets involved in the case, and the Supreme Court said that's wrong. It's not dependent on the prosecutorial procedure. It's just when you're in front of the court, you're arraigned, you were told what you're being charged with, that's the moment of the attachment of the Sixth Amendment right. And it seems to me as a inescapable consequence of that if that's when your right attaches, then if you want a public defender or to apply for a public defender, then the state must allow that to happen and not set up an intermediate step of we won't allow you to even apply for the public defender until you talk to the prosecutor first. Of course, as a constitutional matter, that applies to the Sixth Amendment right to appoint a counsel in cases where there is potentially a loss of liberty on the table, which in our state would certainly include the Class 2 and Class 3 misdemeanors, since even if you don't end up going to jail, ultimately the fact is at the moment you're in front of the court, you are facing the potential of jail in a Class 2 or Class 3 misdemeanor. So my reading of Roth-Gary would be that this bill, as applied to Class 2 and 3 misdemeanors, does fix a constitutional problem and bring the Colorado into compliance with the Sixth Amendment as interpreted by Roth-Gary. There can be exceptions to that. Obviously, if the prosecution comes in at arraignment and says, we will not seek jail time, and that's binding, then the Sixth Amendment right to appoint a counsel doesn't apply. My other point has been well made by previous witnesses, which is in the world if this were 1870, then the consequence of your plea to a Class 2 misdemeanor is right in front of you. You're going to have this many days in jail, you're going to pay this kind of fine, and that's basically, and you'll be on probation, and then that's it, and that's the end of it. But now, in practice, for many misdemeanors, the collateral consequences overwhelm the practical consequences. Oh, I spent the weekend in jail and had to pay a $100 fine, or maybe I didn't have $100 to pay a fine, so I did 24 hours of community service. That's trivially small compared to all the other collateral consequences, which can be the loss of the right to keep and bear arms, which means under federal law, it's a felony if you even hold a gun in your hand. And the person may think, well, I'm not pleading guilty to assaulting my wife. It may understand that might intuitively understand that might have huge consequences. You think, oh, I'm pleading guilty to some kind of disturbing the peace offense because we were having a big fight and I threw a coffee cup against the wall and the cup broke. And they don't realize that the Bureau of Alcohol, Tobacco, Firearms, and Explosives is going to go harvest those records and say, well, yeah, it was just disturbing the peace, but it grew out of a domestic incident, and so therefore you now have a lifetime ban on even holding a gun, or for that matter, a round of ammunition in your hands. A huge consequence. As of course all the professional licensing thing, we live in as my father worked on for many years in the state legislature, a highly overregulated world of professional licensing, which he tried for the point of consumer protection to reduce. And part of this highly overregulated world is that so many people who have committed misdemeanors may be prohibited from ever following a lawful trade or calling in their chosen field. So I think it's right to have even if Roth-Gary weren't there, it would be right as a matter of basic fairness that people who face these huge consequences understand what those consequences are and can make an intelligent plea, rather than maybe saying, you know what, I didn't do it, but the DA is saying, all I got to do is I'm sentenced to time served, and then I've got to go spend 2 weekends doing community service, big deal. They think, they don't realize what a huge deal it is that will impact them for the rest of their lives. And so if they are innocent, this should be the case, we'd want to go to trial. Or even if they are guilty and they are among the 98% of wonderful people who made a single mistake and got caught, have a full eyes open understanding of the gigantic consequences that are going to come to them, which far outweigh the direct criminal consequences. The end. Thank you.
Thank you, Mr. Kopel, and my pleasure is not diminished.
Thank you.
Representative Court.
Thank you, Mr. Chair. Since, Mr. Kopel, since you brought your father up,
Yeah.
I'll say that I'm sure he's very proud of your testimony today.
Well, thank you very much.
Mr. Kopel, let me ask you this. When exactly, precisely, do you suggest the Sixth Amendment right attaches? At what point does jeopardy occur?
Well, as jeopardy is sort of a separate thing, because then the question is, when do you face double jeopardy, and that may not attach till the case goes to the jury. So if the case, you might have jury misconduct, and you have to dismiss the jury and start the case over again.
But for right to counsel.
But for right to counsel, as I understand Rothgary, and I teach constitutional law, but I do not teach criminal procedures, so I'm not an infallible expert here. My understanding of Rothgary is you have a defendant who walks in, and there is the magistrate or the judge. That's the moment at which the Sixth Amendment right to appointed counsel would attach.
Would that also be a television screen at which advisement is occurring?
If the advisement is by a judicial official, yes.
On television?
Yeah, I think I wouldn't, the presence of whether you're in the physical presence of the judge or remotely wouldn't matter. So for example, when Colorado colonizes Mars, but maybe we have judges here who are remotely doing the arraignments, that it would still apply just the same.
Well, we do that under the system now, from jail to court.
Yeah, and yes, that it's you judge, defendant, connected, whether in person or electronically, same. That's how I'd read Rothgary.
Very good, thank you. Any further questions for this witness? Representative Wright.
Thank you, Mr. Kopel. I appreciate your testimony. I'm just curious, you were probably, I think you were here when we heard discussion from the sponsor on the amendment that's being offered, or you may be aware of the amendment.
To pull out traffic offenses and petty offenses?
Correct. With that amendment, based on what I'm hearing, is this legislation does in fact attach directly to Rothgary in order to address a constitutional concern. So should we be distinguishing between charges, whether or not, between felony versus misdemeanor versus petty offense? According to the Fifth Amendment, it still would be considered, I think, constitutionally an infamous crime. It's not a matter of whether or not that person is potentially going to be in jail for that crime, but there may be a fiduciary penalty or a fine levied. So can you tell me where you distinguish that, and would you support this amendment, or do you support the bill as originally written?
Well, I guess Representative Wright, I guess I'd say that whenever you're talking about something that has the possibility of jail, that seems to be what at least the spirit of the Sixth Amendment right to appointed counsel is about. But typically in a traffic offense, one is not facing that situation. But I think the premise of your question is also true, that in the olden days there was an enormous distinction between the felony and the misdemeanor. If you go back to the English common law, a huge number of felonies were capital offenses, and a misdemeanor was whatever, you did that and you served your time, and then it's over. And now that line has blurred. The criminal law has expanded into so many aspects of people's lives beyond the traditional malum in se crimes, and even though we call one thing a felony and one thing a misdemeanor, both have such gigantic collateral consequences on a person's lives, often which exceed even for a felony, where you end up serving a year in prison, the collateral consequences may be far more severe.
Seeing no further questions, we thank you for your testimony.
Thank you very much.